Hey there, this is Attorney Sarah Holmes of Holmes Business Law PC. We are a business and trademark law firm located in Philadelphia and the suburbs. One thing we're going to tell you today, which is a bit controversial, is why you should not let your accountant form your business entity. Now, nothing against accountants or CPAs. In fact, we love accountants and CPAs. We refer a lot of business to them. We do not ever answer accounting questions for clients. We personally pay our law firm accountant a good amount of money each year to keep our taxes and all of our accounting compliance and our books in good order. So we love accountants. First of all, nothing against accountants, but why should you not let them form your business entity? They're perfectly capable of doing so, but what are the problems with doing that? Number one is an accountant is just that. They're an accountant. Their expertise is with the tax laws, how things are taxed, maybe the bookkeeping, things of that nature. They are not lawyers, and so they're not experts on the legal side of entity formation. Anytime you're looking to form a business entity, there's really two different things to take into consideration. One is obviously the tax consequences of the entity, but number two are what are the legal consequences of forming that entity. What we find often is that when an accountant forms an entity for people, they do not give people the proper legal documents that need to go with an entity. For example, let's say you ask an accountant to form your limited liability company. What we find is the accountant does not give people an operating agreement, which is really the legal document that needs to govern the entity. And if you have a business partner, not having an operating agreement or having a deficient one or having one that you really didn't have any hand in drafting or making decisions on is certainly likely to cause problems down the line with your entity. The other big problem we see when accountants form entities is they may recommend that the client form an S corporation. And what they do is they set up an actual corporation, a C Corp legal entity, and then they elect tax status as the S Corp tax treatment. Fine. What's the problem with that? The problem with that is now the client has a corporation as their business entity. If they are a single member or maybe have one other business partner, those people now having to manage a corporation and the corporate formalities is number one, something they probably don't have any idea about. And number two, something they're not likely to do, which is keeping corporate minutes, corporate resolutions, and all the documents. So sometimes we see people for the first time, maybe 3 years down the road, after they formed the corporation, and we ask them, where are your meeting minutes? Where's the resolutions? And they'll say, I don't know, my accountant formed this 3 years ago. I don't have any of that stuff. That's highly problematic. If you're not doing those things and you have a corporation, you are blowing the protection of the corporate form, meaning if someone wants to sue your business, they may be able to get at you personally, which is the whole point of forming an entity in the first place. So that again is another danger of having an accountant form your entity. So next time, if you need an entity to form, we strongly suggest you consult with legal counsel, have an attorney form the entity, and then if you have questions on the tax side, like how should this entity be taxed, then we refer you to the accountant, we get input from the accountant and make sure that both of those things align. It's really, really important that your entity aligns both from an accounting standpoint and tax standpoint and from the legal standpoint. So if you need any help with an entity in Pennsylvania, New Jersey, or New York, feel free to reach out to our office. Our phone number is 215-482-0285. Thanks.